Hello, this is Denny Miller, co-owner and managing broker with Zenith Properties here in Vancouver, Washington. In this video, I'm going to talk about how eviction laws in Washington have changed now that the COVID eviction moratorium is over, and what you need to know as a landlord to be successful in evicting a tenant for non-payment of rent. And I'll provide some clarity around the new timelines for each part of the eviction process so that you can have some idea how long it will take to regain possession of your property. You're probably aware that the moratorium on tenant evictions that went into effect across the country in March 2020 lingered on for a full year and a half in the state of Washington and was finally lifted on September 30th, 2021. Even after the eviction moratorium was lifted, special rules remained in effect, making the process confusing and adding additional time. In fact, to this day, certain jurisdictions such as King County, the cities of Seattle, Tacoma, and Spokane have enforced their own special rules, making it even more difficult and time-consuming to evict a tenant for non-payment of rent in those areas. I will not be addressing these special local rules in this video. As of the date of this recording in September of 2023, evictions in the state of Washington are now governed by changes in the Landlord Tenant Law from Senate Bill 5197 that was passed this year and went into effect on July 1st, 2023. Under the new laws that amended evictions in July, the process works like this. If rent is due on the first day of the month and is not paid by the 6th of the month, the landlord can and should serve a 15/30-day notice for the tenant to pay or vacate. If the tenant fails to pay the rent due, the notice will expire on midnight of the 20th, and the landlord can file an eviction with the court on the 21st day of the month. The exception to the 14-day timeline from when the notice is served is when the property or the tenant is receiving some sort of federal funding. In these cases, the timeline is extended to 30 days before the landlord can file an eviction with the court. Examples of the type of funding that will make the required notice 30 days are the following. Any property in which the landlord has a federally backed mortgage, including VA, Fannie Mae, Ginnie Mae, USDA direct or guaranteed loan, or an FHA loan, or any property in which the tenants are receiving housing assistance, such as VHA, VASH, that's vouchers for veterans receiving federal housing assistance, Section 8 and HUD tenants, and tenants living in a tax credit building, which are typically larger multifamily properties. During the 14 or 30-day period, the tenant can seek financial assistance from a nonprofit or governmental agency. If the tenant receives a pledge of assistance during this period, the landlord must suspend the notice for an additional 14 days. This allows for the additional time needed for the agency to provide the necessary funding for the tenant to pay the past due rent and cure the notice, which stops the eviction. After the eviction is filed with the court, the tenant must legally be served the filed paperwork. Typically, this is done by a process server working for the hired attorney's office or by the sheriff. This can usually be done within a day or two of the filing. Once service on the tenant has been completed, the court will set a date for a hearing for the parties to show cause. This is where the landlord will show their reasoning on why the tenant should be evicted. Well, they didn't pay the rent, Your Honor, and the tenant will have an opportunity to show why they shouldn't be evicted. Typically, show cause hearings are held on Thursday at the courthouse. Depending on the day of the week that the service is completed, and depending on the court's schedule, this can add 1 or even up to 2 weeks from the time service is completed until the parties get their day in court to show cause. To be successful at the show cause hearing, the landlord or their attorney will need to come prepared with copies of lease agreements, notices, tenant ledgers, communication including any texts or emails, photos, etc. All of the evidence needed to prove their case. Presuming both parties attend the show cause hearing, there are several possible outcomes. The tenant could offer to pay the amount of past due rent in full. The judge could issue a writ which allows the landlord to proceed with the eviction, or the parties could agree to negotiate a payment or settlement agreement for the tenants to catch up on the past due rent. I have a word of caution regarding payment or settlement agreements with tenants in eviction court. Any agreement that needs to be very carefully written to make sure it includes language that permits a writ which allows the landlord to proceed with the eviction if the tenant fails to pay and comply with the terms. Otherwise, if the tenant doesn't pay, the landlord will have to start the process all over again. If the tenant doesn't show up to court for the show cause hearing, they will be in default and the judge will issue a writ allowing the landlord to proceed with the eviction. When a writ is issued, the landlord will also receive a monetary judgment for unpaid rent and the landlord's legal fees. When the parties engage in a payment or settlement agreement without a writ, landlords are not entitled to receive payment for any of their legal fees. Once the judge issues the writ allowing the landlord to proceed with the eviction, a date will be set for the sheriff to lock out the tenant. The sheriff lockout date is usually 3 or 4 weeks from the date the writ is issued. In many cases, after the writ is issued, the tenants will actually voluntarily vacate the property before the sheriff lockout date. If not, on the day of the lockout, the sheriff will meet the landlord at the property, making sure the home is safe to enter. Landlords need to arrange in advance to have a locksmith meet them at the property so the doors can be rekeyed, securing the property and preventing the evicted tenant from returning and trespassing. If the tenant leaves items at the property, which is usually the case, the landlord's required to store anything with a garage sale value of $500 or more. Additionally, if the tenant submits a written request for the landlord to store the possessions, right up until the lockout, the landlord must do that. If there is no written agreement or a request, or nothing left of value that's over $500 or more, the landlord can then dispose of everything. Well, there you have it. A good, in-depth breakdown of all the key steps to conduct a successful tenant eviction for non-payment of rent in the state of Washington, not including any of the additional rules that may apply in certain local jurisdictions. The amount of time that it will take from the first day of the month when the tenant stops paying rent until a landlord can regain possession of their property at the sheriff lockout will, in the very best case scenario, be at least 50 days. That's 50 days, up to, in a worst case scenario, of as much as 90 days. That's 90 days. This, of course, presumes that nowhere along in the process did the landlord or their attorney make any mistakes in following the process to the letter. Any mistake along the way, from not having the exact language in the original notice, notices not being properly served, not being prepared with the proper documentation at the show cause hearing, delaying in getting a writ because the tenant convinced the landlord to engage in a settlement agreement that they end up not performing on, to not getting on the calendar right away for a sheriff lockout. Any of these mistakes will extend the eviction process by many weeks. Yikes! So what's a landlord to do? Get professional help if you need to evict a tenant. Without question, you'll need to hire an attorney who specializes in Washington landlord tenant law and has significant experience doing evictions. The cost of having a competent attorney to handle the eviction is a lot less than what you might expect, and certainly less than all the income you'll lose if you let the non-paying tenant stay. Or you can hire a professional property manager like Zenith Properties who knows Washington state eviction law. We have an established relationship with one of the very best eviction attorneys in the state. We know how to collapse the time frame it takes and how to minimize the cost of regaining control of your property. Also, we will put in the place of your non-performing tenant a well-qualified tenant who will replace the income you are losing every day while a non-paying tenant is holding your property hostage. Contact us by calling the number or clicking the link in the description for a no-obligation consultation on how Zenith Properties can make owning rental property and being a landlord in Washington state free from complicated and expensive eviction hassles. This is Denny Miller with Zenith Properties, wishing you the very best. Thank you.